Yep.
So welcome everybody to this book launch organized by the friends at Stas Pisa, Giuseppe Martinico, Giacomo Delle Donne, and many others. And we will discuss today a timing book authored by Professor Mark Graeber. I will present Mark Graeber in a second, and the title of the book is Punish Treason, Reward Loyalty, the Forgotten Goals of Constitutional Reform After the Civil War. Is really timing because it helps us to also understand what is happening in the US constitutional democracy with regard to the recent event dealing with Trump candidacy to the election. I would like to introduce Professor Mark Graeber. Mark Graeber is a friend. I'm honored to say that he's a close friend, but above all, he's a professor, he's Regent Professor at University of Maryland in Baltimore, and is a prominent scholar in US constitutional law, constitutional history, and he authored several books, milestones in the constitutional scholarship in the US. A New Introduction to American Constitutionalism, Dred Scott and the Problem of Constitutional Evil, and he is the co-editor of American Constitutionalism, Structure and Powers, and American Constitutionalism, Rights and Power, among all other publications. So it is really a pleasure to have Professor Mark Graeber with us to discuss his book. I will give the floor to Mark, and after that, after Mark's speech, I will introduce our discussant. So, Giuseppe, if you want to
share, yeah, here we go.
The book.
This is the beautiful cover of a fantastic book, so Perfect Chemistry. I think we will enjoy the show, and I look forward to listening to our fantastic speakers. Great.
So I will give immediately the floor to Professor Graeber.
Well, thank you very, very much for the kind introduction. Professor Baraggia did not mention the real reason I'm memorable in her family, namely I introduced her children to American-style cupcakes. And this is, if any of you come over, I'm very happy to introduce you and your children to American-style cupcakes. A bit of an apologies. I'm delivering this from my bedroom where I have a working computer. You may see on your screen an office with an empty chair. That is the office with the non-working computer. So we'll just have to put up with a rather strange surrounding for giving an academic talk. And again, thank you so much for the organizers and for all of you for being here. As I think all of us know, the one thing we crave most as academics is an audience, because we like to think our ideas matter and they hope to matter to other people. Well, this is the first book in a series of books on constitutional reform in the United States. And it works in about 3 disciplines: history, political science, and law. With respect to the finding that's closest to history, most of us in the United States know the 14th Amendment has 5 provisions. Traditionally, it is taught as only having 2. There is provision 1, then an ellipsis, ... provision 5. ID, there may be 2, 3, and 4 existed because who knows, they were being paid by the word and they had to write a 5 provision amendment, but they serve no purpose. What I try to show is not only do sections 2, 3, and 4 serve a purpose, but to the framers, they were far more important than section 1. The political science is why this is so. We are obsessed, and not just, I think, Americans, but looking at the comparative group, we are obsessed with Section 1 because Section 1 is about rights. And most of our understanding is constitutions are instruments that protect rights, to the point where Giovanni Sartori said a constitution is defined by a set of rights that limit government. This is not what Americans believe throughout most of American history. Constitutionalism, for them, was a set of structures that was designed to produce a government that would, among other things, protect rights, but also serve broader interests. And they didn't believe that rights were best protected by simply listing them, or listing them and saying, by the way, we expected courts to protect them. They believed you best protected rights by having a structure of government that would privilege the selection of people who would protect those rights and pursue wisely other national interests. The legal problem is, how then do you interpret constitutions, particularly constitutional rights provisions, when you stop understanding them as limits on government to be enforced by a judiciary, but rather as governmental purposes to be primarily implemented by elected officials? So rather than thinking of the Constitution of the United States as saying there's a legal ban on slavery and there are legal rules about discrimination, what would it mean if we understood the Constitution as committing Americans to the project of abolishing slavery, abolishing a slave system, abolishing a slave power? What this volume, I emphasize, it's the first volume in a series that I'm hoping will require I be kept alive for 10 years so I can finish it. This focuses on the goal of constitutional reform. And in particular, there are two goals. The first is ending a civil war. And this is actually a problem I find in a great many constitutions. A great many constitutions specify the rules for going to war, as does the Constitution of the United States. But the Constitution of the United States, and I note a number of other constitutions, do not specify the rules for determining when the war is over. Is the war over when the other side comes up, hands up, and says, we surrender? The president is the commander in chief. Does the president, when the president says the war is over, is the war over? Congress has the power to declare war. Is the war over when Congress says the war is over? And as Sandy points out, there's a very good book by a historian named Greg Downs from University of California, Davis, who writes about the conflict between the president and Congress over, was the Civil War over and who said so? And it's very clear. Congress said, we determine when the Civil War is over, and we determine the conditions. And the 14th Amendment is part of Congress attempting to determine the conditions for when the Civil War is over. Well, what was Congress interested in doing? And the argument of the book is that the primary goal of Congress was to ensure that for the foreseeable future, the United States would be governed by loyal people. Now, when I say this, a great many Americans say, no, no, their goal was to ensure the end of slavery, that prevent race discrimination. And I said, that's one of their goals, but it's important to understand two things. First, it's not the only one of their goals. Second, they didn't think the goals could be achieved by simply saying no slavery, no race discrimination. Because what they had experienced, they had passed a constitutional amendment that said no slavery, and the former Confederate States immediately passed a series of laws that have become known as the Black Codes. They said this is not slavery, but no African American can own land. All African Americans are required to work. All African Americans must get passes if they want to travel. They can't have weapons, and they certainly can't use them in self-defense. In other words, what they did was they basically reenacted slavery. And so people in the North concluded, if these people are allowed to rule, there will be re-enslavement of African Americans, but not only re-enslavement of African Americans. It was also open season on loyal white Unionists in the South. Many of them were being forced to flee their homes, and some of them were butchered. Southerners were demanding that the United States pay the Confederate war debt and compensate slaveholders. They were saying if they got into Congress, they would not pay pensions for Union soldiers and for the widows of Union soldiers. And one of the things you see, we tend to edit out everything that doesn't concern race, but if you read the speeches, they are just as concerned with the fate of the white Unionists in the South and the Union widow in the North as the African American in the South. So there are broader aims here. So how do you deal with the problem of rebel rule? You have loyal people rule. Well, who are they? Turns out they have a theory. So it's a rather important theory. It's one we've forgotten, but it's one that certainly has a good deal of empirical accuracy, and I think some theoretical accuracy as well. Namely, the loyal people are the Republican Party. The Republican Party is the party of the people who remained loyal during the Civil War. And in the 19th century, Americans practiced a form of popular constitutionalism in which a party that got the majority of the votes was entitled to make its understanding of the Constitution the official law of the land. So it's not the judiciary that's really the authority, it is the party. So Abraham Lincoln, when he speaks, Lincoln never says, I have constitutional power because I'm president. Lincoln says, I have constitutional power because I'm the leader of the majority party. Who else is loyal? African Americans. So when Republicans talk about African Americans, they sometimes use the Jefferson language, all persons are created equal. But more often, their speeches are, these are the African Americans. They were loyal. There are long speeches about the African American who guided the lost Union soldier back to the lines, who fed the Union Army, who betrayed their masters and enabled Union success, not to mention 200,000 African American troops that probably turned aside in the Civil War. That's what they talk about. This is why, while many of them are actually for women's rights, African Americans get their rights now because they were loyal. Well, what's the problem? The problem turns out to be, and this is the reason for the 14th Amendment, it's one of the great whoops moments in constitutional history. The 13th Amendment freed the slaves and everybody celebrated. Only after the 13th Amendment was passed did someone note a little problem. For approximately 80 years, Northerners had complained about something called the 3/5 clause. 3/5 clause is a clause that said the number of representatives you get and in Congress and the number of votes in the Electoral College is equal essentially to your free population plus 3/5 of other persons. So if South Carolina had 500,000 whites and 500,000 slaves, they got, say, 5 representatives for the whites and 3 for the slaves. That was 18 extra representatives. It turns out many crucial votes, both for presidency and in Congress, turn on those 18 extra votes. Well, what happens after the 13th Amendment? Those 18 extra votes turn into 30 extra votes. 30 extra votes for African Americans who are not going to be allowed to vote. So assume that Democrats in the party opposing the Republicans get all the votes in the South. It turns out they basically need only about 1/3 of the votes of the North, maybe 2/5, to rule the country. This is not, one of those horrible, fantasies we make up. Literally this morning I was reading from the leading African American newspaper in the country when someone said, "What will Democrats do if they come into power?" And the newspaper said, "First, you need to understand if the Constitution isn't changed, we're talking about the next election. They will win the next election with the solid South and 2/5 of the Democratic vote in the North. When they do that, African Americans go back to slavery, whether we call it slavery or not. White Unionists are chased from the South, and Northern credit is ruined because they do not pay the debt." So now you can see the different provisions of the 14th Amendment have different valence. Hardly anyone, outside of one person, was concerned with the rights provision that we spend all our time on in the United States and abroad, the Citizenship Clause, the Equal Protection Clause, privileges and immunities, due process. These are called the greatest things in the American Constitution. Outside of one person, they spent little energy because they realized these would be mere parchment barriers if the electoral system wasn't changed. And by the way, if the electoral system was changed, they would be unnecessary because Congress could do all of this under the 13th Amendment. What did they care about? Well, from their speeches and newspaper articles, they cared about Section 2, which is the apportionment. What Section 2 does is get rid of the 30 vote bonus. It says, from now on, you get representatives in proportion to your population, but if you disenfranchise any men over the age of 21 for reasons other than crime or participation in the rebellion, you lose that proportion of your representation. So if South Carolina disenfranchises 500,000 African Americans, their representation goes down from 10 to 5. And the idea here was simple. South Carolina and the Confederate States now have a choice. Option number one, they disenfranchise. But if they disenfranchise, they lack the power to control the national government. Option number two, they enfranchise. Now they can control the national government. The problem is, if you enfranchise 500,000 African Americans, chances are 5 of your 10 representatives are going to be African Americans. Now, if what you decide you really want to do is get internal improvement money south, the 5 whites from South Carolina will join hands with the 5 African Americans for South Carolina and agree South Carolina should get its share of federal spending. But if South Carolina is going to try and reinstitute white supremacy, they lose those 5 votes. So the only way South Carolina can get its fair share of federal money, the only way South Carolina can get policies that benefit South Carolina is by first enfranchising African Americans and then saying, and by the way, our program is railroads for the South. Our program is not Jim Crow white supremacy. And what Republicans say when that happens, there'll probably be 2 biracial parties in the South. And when there are 2 biracial parties, our work is done. The parties will figure out what race relations are, and we can trust a party system in which African Americans have a prominent voice to protect African Americans. Section 3. Section 2 deals with the nation. Section 3, which has become famous because disqualifying Donald Trump, deals as much with the states. And here Republicans had a theory. It's a theory that's pretty common. Proves to be wrong, but it's pretty common even now. Namely, the Civil War is about an elite that led the masses into secession. That the average Southern farmer was really like the average Northern farmer. Neither was a great bastion of racial equality sentiments, but they weren't going to revolt. They weren't interested in slavery. If you could just cut off the head of the leadership class in the South, what would follow would be ordinary, loyal government. So Section 3 says, if you held an office, state or federal, before Civil War, and you participated in the insurrection, any insurrection, you were disqualified from holding office. You neuter the Southern leadership class and you assume a better leadership class is coming. Section 4 does the economic neutering of the Southern leadership class. It says, nope, if you held Confederate bonds, you don't get a penny. They're now worthless. If the winter is cold, you can use them to heat your home, but that's their only use. No payment for emancipated slaves. But to the North, guaranteed payment of the Northern debt and Northern obligations to soldiers and widows. So we've enriched the Northern capitalist class. We've impoverished the slaveholding class, And notice this simply isn't economic. This will obviously have political consequences because the South will now need Northern money to rebuild. Now, most of this is an American story, but I'd like to suggest it's also a comparative story. Several years ago, Making Rights Work, Versteg and Chilton, I think won the Icons Prize because it noted that merely including rights in a constitution didn't mean your constitution protected the rights better. And one of the things the book highlighted, only implicitly, was we have all, United States, Italy, wherever, adopted a theory of constitution that says you write the rights down, you have an independent court, and everything is hunky-dory afterwards. We've learned everything is not hunky-dory afterwards. What the American experience in the 19th century and 18th century suggests is that constitutional reformers don't simply write rights down, but they have a theory of underlying politics that will make the rights work. And rather than focus on whether the courts are interpreting the constitutional rights correctly, we might spend greater energy in asking, is the constitutional system working as the framers intended? If not, what has happened and what might we do to fix the constitutional politics if you don't like what a constitutional system was generating? Because the story we tell that what they did is add new rights doesn't capture what they did. The story is not a betrayal of rights, but of a structure that didn't work. And we are similar, and here's the point Sandy Levinson, I suspect, will make in his comments, that if you don't like the rights in the United States now, look to the structure, not to their definition. Thank you.
Thank you very much, Mark. Terrific presentation of your book. I have myself some questions, but I will give immediately the floor to our discussants. First, I will give the floor to Professor Sandy Levinson, who is Professor of Government at the University of Texas at Austin. Professor Levinson is a leading constitutional law scholar in the US. Also, he is an expert in legal history and in foreign and international law. He authored several books. I would like to mention my favorite, which are Constitutional Faith, written in stone, Public Monuments in Changing Society, and we have 2 editions of this book. Our Undemocratic Constitution, Where the Constitution Goes Wrong and How We the People Can Correct It, and Democracy and Dysfunction with Jack Balke. He also co-authored several edited volumes, and I would like to mention just the last one, Constitutional Democracy in Crisis, with Mark Tashnet and with Mark Graeber. And we are working to a second edition of this book, so I would like to mention also this. So I will give immediately the floor to Professor Sandy Levinson, and I really want to thank him for being with us today. Please, the floor is yours.
It's absolutely my pleasure. Let me pick up immediately from what Mark has said, because he's absolutely correct that for at least the past couple of decades, I have been focusing on structures rather than rights. And it is not, I always point out, that I don't like rights, that I don't think they're important, but I think that not only Americans, but most people after World War II have tended to define constitutions as rights-bearing instruments and have turn their attention away from structures which strike most professors, like most of our students, as dull and boring. I don't know what it's like in Italy, but I do know that it's often difficult to stir up much interest in first-year students taking an introductory course in constitutional law on the structures of American government. It is not difficult to stir up discussions about abortion, affirmative action, guns, free speech, and the standard topics, torture, the standard topics of rights and international human rights. I think this is a grievous problem in the way we teach constitutional law in the United States. I don't know enough about the teaching of constitutional materials elsewhere, but I do think it is a deep problem in the United States. And one of the reasons that I think that Mark's book is so clearly the best book ever written on the 14th Amendment, but also one of the best books ever written on the American Constitution generally, is its focus on politics and structures along with rights. But Mark has said a lot about that, and I don't want to repeat it here. I do want to put his remarks within the context of what I do think is an international discussion, which is militant democracy. Militant democracy, as all of you know, the idea was created, particularly I think by Karl Lowenstein, but by German constitutionalists during and after World War II, who were properly concerned with the great dilemma in Western culture. How is it that Germany became fascist and Nazi in a way even beyond Italy? The two, Italy, the birthplace of the Renaissance, Germany, the birthplace of, or most people viewed as the birthplace of the Enlightenment, turned into very, very nasty political systems. And how did that happen? And so one of the arguments that Lowenstein made is that it happened because there was a certain indifference to the actual political views of those running for office. And in the name of democracy, which, and here, I will treat American exceptionalism, because I think there's no doubt that the United States has the most capacious notion of freedom of speech, the protection of hate speech, for example, of any country in the world. And when I was growing up, I was inspired by Oliver Wendell Holmes's theory of the First Amendment, which said, among other things, if the people want to install a proletarian dictatorship, then that's their right. In a case which I suspect some of you might be familiar with, Lochner versus New York, which is usually taken as the anthemic case for judicial overreaching, Holmes's dissent said, it's not our job, in essence, to guard against tyrannical legislation. If the people want tyrannical legislation, it's our duty to enforce that, unless you can find something very specific in the Constitution that bars it. And Holmes quite properly didn't find anything in the Constitution that barred regulation of maximum hours. And I dare say none of us view that as tyrannical legislation. But the point is that Holmes said it really wouldn't matter. When I read those dissents, and they usually were dissents, in my youth, I embraced them, in part because, quite frankly, I didn't think there was the slightest danger in the United States that we would become a proletarian dictatorship. I didn't think that there was the slightest danger that we would become a fascist dictatorship. I was raised, and I'm talking about, I entered graduate school, I'm chagrined to say, 62 years ago. It was the height of the emphasis in American political science and American history of so-called consensus politics, the idea that the United States was a wonderful country organized around a liberal democratic consensus that meant a kind of Holmesian notion of toleration of speech. Anything went. Anybody could run for office on any platform at all because you could rely on the Democratic electorate to keep us within a quite modulated consensus. Now, in retrospect, that consensus we all today would recognize rested on an indifference to racial discrimination, an indifference to the treatment of women in many respects. Women could vote, but women could still be functionally barred from participating on juries. There were very, very few women in politics, and so on and so forth. Again, you don't have to be very sophisticated or knowledgeable of American history to know that that consensus vision has collapsed and is no more in the way we approach American politics or American constitutionalism, so that the emphasis is now on polarization. And how do constitutions operate in highly polarized societies, rather than how does the constitutional order or Supreme Court operate in a consensus-oriented society where, the spectrum of opinion among elites runs the gamut from A to C, but that's just about it. Whereas, again, that world doesn't exist anymore. So I am one of those people who now finds myself thinking more seriously about militant democracy than I used to think. As a good American, I'm ambivalent about militant democracy because it necessarily gives political authorities power to suppress those they view as their potential political opposition. And there are good reasons to be fearful of that. That being said, I'm no longer so attracted to the Holmesian marketplace of ideas where we all compete in elections and whoever gets the most votes. And in the crazy American political system, and it is a crazy system, you don't need to get the most votes. It's not even a true little d democratic system, because as all of you know, 2 American presidents in the last 20 years got to the presidency without coming in first, and therefore, in addition, without getting a majority of the votes. But we have this very, very odd system called the Electoral College. So now let's bring this back to Mark's book. Sections 2 and 3 are about militant democracy. They say that one can have a desirable constitutional order that recognizes important rights. And Mark, I think, doesn't deny that the 14th Amendment has something to do with rights. Rather, the importance of his book is that rights are not self-enforcing. Only if you have a political system and a set of political structures committed to a certain vision of rights, and when I say a certain vision of rights, I mean a controversial vision of rights that other people are going to be very much opposed to, like rights for African Americans, or later rights for women, or ethnic minorities in general. So how is it that you protect a political regime devoted to what you view as the most attractive set of rights, well, one of the things you can do is to prevent opposition to what you regard as the desirable vision of a liberal constitutional order, to protect yourself against the possibility that political parties committed to alternative visions will be able to participate and win elections. You can do that in one of two ways. You can try to prevent those who manifested their commitment to what you regard as antagonistic values from voting. So if they can't vote, then by definition, it's going to be harder for people representing those views to be elected. But you can also try to prevent people from running for office at all, insofar as politics is this dance between elite leaders and mass followers. And so, you've got, if you're really committed to militant democracy, you have to attack both. You have to try to prevent the rise of mass movements in the electorate that might have antagonistic views. And you also need to prevent the rise of particularly charismatic political leaders who might take you to victory. Is this a desirable vision of politics? The importance of Marx's book historically is to demonstrate beyond reasonable doubt that the framers of the 14th Amendment, and Marx is absolutely right, the 14th Amendment has 5 sections, and the most important ones in terms of understanding what might be called constitutional politics are sections 2 through 4. They had the vision that Marx is describing, that only one party could be trusted to support what Lincoln called the new birth of freedom. The paradox, incidentally, is that I believe that we have almost literally no idea what Abraham Lincoln's actual Reconstruction policy would be. That I think Abraham Lincoln, to be altogether blunt, is one of these figures who actually benefited in terms of his historical reputation from exiting the historical stage at a very key moment before he had to make very tough decisions as to how much of the new birth of freedom for African Americans he would sacrifice in favor of what he called in his second inaugural a vision of charity, malice toward none, and charity for all. How much of Reconstruction would involve charity for the defeated Southern whites, and how much of Reconstruction would involve a very strong militarily enforced program of justice for the formerly enslaved African Americans. We just don't know. And Lincoln's own career is full of compromises. But as I say, the point is not only the historical understanding of the 14th Amendment, where Marx's book now has pride of place and has to be read by anybody who teaches American constitutional law or American constitutional development. But within the context of an international audience, on the assumption that not all of you are that interested in the intricacies of American constitutional development, I do think the issue very much worth discussing is whether the model of party hegemony and militant democracy defined as trying to prevent those you view as your really crucial political opposition. The Republican Party might not have wished to be a single party in a one-party state, but it is clear that they wish to be the dominant party, and that other parties they might feel completely benevolent toward would have to share their vision. And they really did not feel any genuine benevolence toward a big D, Democratic Party, whom they correctly viewed as antagonistic to their inclusive vision of rights for all, and at worst might even have been receptive to the reinstitution of slavery. So I want to point out, Mark mentioned, but I would underline, in Section 4 of the 14th Amendment, the constitutional bar against compensation for slaves. Within American constitutional law, I think that's a really very important section because, as all of you, I'm sure, know, you wouldn't be here today if you weren't interested, at least somewhat, in the American Constitution. The American Constitution is very pro-property rights and pro-compensation for private property that is taken. Emancipation was one of the greatest seizures of private property in world history. And a well-trained American lawyer, including Abraham Lincoln, could believe that loyalist slaveholders, and there were loyalist slaveholders, most slaveholders supported secession, but not all slaveholders, including slaveholders in what we call, slave states, that is, the seceding Confederate states. Some of them were loyalists. Were they entitled constitutionally to compensation? I think that a serious lawyer in 1865 could come up with arguments, yes. And one could easily imagine that one way of binding the nation's wounds and bringing the white populations of the North and South together after the war would have been a decision by a Democratic Congress to give compensation, at the very least, to the loyal slave owners, and maybe along the way to a lot of disloyal slave owners who weren't, let us say, officers in the Confederate Army or officials in Confederate governments. Section 4 closed off that possibility, and it tends to be ignored because I think today most Americans find it unthinkable that slave owners could be entitled to compensation. But I would point out that one of the real scandals of European history is that after Haiti became the first Black republic in the world by revolting against France, the restorationist government in France in 1825 sent ships to Haiti demanding reparations for French slave owners who had lost their property as a result of the Haitian Revolution. And Haiti agreed to pay reparations and was paying off that debt, I think, even after World War II. So this issue is not merely an abstract academic issue. It can become a very real issue of practical politics. And, Section 4 precluded that as well. But as I say, I think in terms of this audience, I really would be interested in your own reflections about militant democracy and whether Sections 2 and 3 present an attractive model or perhaps something to be scared of?
Thank you very much, Sandy. Also because so you raise an important topic also for Europeans. So the concept of militant democracy now is on the table also. If we look at the recent intervention of the European Union vis-à-vis Hungary, for example, and Poland, so it is a concept that is regaining momentum in the debate also in Europe. And so it is interesting to compare the situation in the US and in Europe about this concept of militant democracy. So I think we will be back discussing this in the Q&A session. And now I give the floor to our last discussant, who is Leonardo Pierdominici. Leonardo is a friend, but above all is a professor of public comparative law at the University of Bologna. He is author of several publications. Above all, he authored 2 books. One about the mimetic evolution of the Court of Justice in comparative perspective. And the most recent one is about the evolution, revolution, involution of Israeli constitutionalism in comparative perspective. Leonardo is an expert in courts, constitutional adjudication, and studied extensively the legal context of the Israeli system. So please, Leonardo, the floor is yours.
Thank you very much. Thank you very much, Antonia, for your presentation. Thanks to organizers for having me. Of course, I speak after to measure experts of American constitutional law, but of course, I will limit my intervention to a comparative perspective. I will play just this role. In fact, Professor Graeber's work is so deep, well research, persuasive, that it is impossible for a scholar coming from a different jurisdiction to offer specific comments on its details, on its merits. Still, Professor Graeber's work is also very enriching, specifically in a comparative perspective, as Professor Levinson into that. And I want to give some comments on certain aspects that I found particularly interesting in this sense. The first comment I want to make actually is a follow-up to Professor Levinson general comment and even to a discussion Professor Graeber and I had some months ago in Milan, thanks to you, Antonia, and to the organization of the previous presentation of this book, precisely on the possibility of framing Section 3 of the 14th Amendment in comparative terms as a prototypical form of militant democracy. As Professor Levinson said, militant democracy is a familiar concept for a European scholar, intended as a legally authorized but exceptional restriction of certain basic political rights aimed to preemptively marginalize those undermining liberal democratic institutions. It pertains precisely to constitutional politics and structure, as well as constitutional rights. It is a concept that is usually traced back to Karl Löwenstein's appeal to robust responses to fascism in 1930s Europe, and could be applied throughout the 20th century to all the forms of authoritarianism of different colors and forms we experience in our continent, and we had a different experience from the US. The concept of militant democracy recently reemerged, propelled by major troubles of our democracies, terrorism and counterterrorism, religious fundamentalism, more recently the rise of populist and illiberal movements. These recent troubles are well known in Europe as well in the US. And Professor Graeber, in remaking the history of the 14th Amendment and looking at the constitutional politics reasons of the Reconstruction Amendments, suggests how the 14th Amendment was constructed precisely, as a European scholar would say, as a prototypical form of militant democracy, well before the 1930s. What Professor Graeber suggests us in comparative perspective is that we should not only look at the mentioned recent challenges per se as opportunities of potential new application of old tools, but we should also look backwards to the reasons why certain tools were forged in our constitutional systems, to their original inspirations, to better understand the use it can be done today of those instruments to counter illiberal new trends. Still, the point I want to make is that militant democracy is a general concept. There are major differences among the legal instruments one can link to this general idea, to this general concept of militant democracies. There are many differences in comparative perspective, and one could say that some of these differences are being recently emphasized by the Supreme Court judgment of 3 weeks ago in Trump v. Anderson. When we speak of militant democracy, we always speak, this is a commonality, in Madisonian American terms of making the constitution of the government sufficiently robust against the weakness of mere parchment barriers. And in particular, as Professor Graeber emphasizes in the book, this is particularly true in periods when a constitutional new funding is perceived as necessary. Still, we have major differences. In some jurisdictions, like the US, the Constitution provides for individual disqualifications in the form of Section 3 or in the form of impeachment process. On the other hand, in continental Europe, militant democracy is typically linked to group bans, to party bans. In some other jurisdictions, such, for instance, Israel, that you mentioned before, we have both the kinds of instruments, both individual and party bans. For instance, according to Section 7 of the Basic Law, the Knesset, the legislation can prevent candidates and parties from running if they engage in speech denying the Jewish and democratic nature of Israel, inciting racism, supporting the armed struggle, or terrorist organizations. There is also another difference. In many jurisdictions, bans are made through administrative or better judicial means. This is the case of almost all the European experiences. On the other hand, for the US, Trump v. Anderson suggests that, at least for the majority of the Supreme Court judges, a prior intervention of the Congress, of the legislature, is necessary. Given these basic differences, my question is, do you think that Section 3 of the 14th Amendment can be framed like that, as a prototypical form of militant democracy, or is a different animal? In this perspective, can the Reconstruction Amendments, given also their general jargon, be read as another, maybe forgotten, American constitutional lesson for what Europe forged almost 1 century afterwards? A second point I want to make is about constitutional interpretation. As Jamal Green put it in a famous article some years ago, in the last decades, I would say, originalism has been the idiom of judicial restraint in the US, and its proponents defined originalism as being uniquely appropriate to constitutional adjudication because it would be able to offer articulable, transparent criteria for discerning the meaning of ambiguous constitutional text. This idea became influential elsewhere and even in more recent constitutional settings as the basis, the general basis for exercises of judicial restraint. In here, if I understand Professor Graeber's arguments correctly, we face a paradoxical twist, or maybe two. Why I say so? Firstly, because in discussing Section 3 in its historical terms, reliance on original understanding of certain constitutional norms could not be the idiom of judicial restraint, as Thomas Green put it, but of a possible major judicial intervention in the political realm, or in any case of interventions of the kind. Secondly, even if one accepts the arguments of some of the originalist critics of Professor Graeber, who argue about original uncertainty in the scope of application of Section 3 in terms of self-applicability of a norm, of inclusion of a precedent in the scope of a norm, and so on and so forth, we must in any case conclude that originalism in this specific matter does not offer, in any case, clear, articulable, transparent criteria for discerning a specific constitutional meaning. I would say quite the opposite. Moreover, the concurring opinion of Justices Sotomayor, Kagan, and Jackson in Trump v. Anderson points precisely at the lack of judicial restraint of their originalist colleagues writing the majority opinion. So actually, points at a betrayal of the originalist institutional ultimate purpose. So my question is, can we say that the case of a forgotten 14th Amendment is a paradigm of crisis or even defeat of originalism, of these doctrinal terms in one way or the other? A third point I would like to make, a final point, is on the future perspectives of our debate. Section 3 of the 14th Amendment was forgotten, as Professor Graeber puts it, but was not in desuetude. Desuetude of constitutional norm is possible, but in this case, there was no conscious sustained non-use, there was not public repudiation of constitutional norms. Simply, for nearly a century and a half, there was no reason to apply that those norms and to discuss Section 3 and consequential disqualifications. So we could all forget this part of the 14th Amendment, as you put it, and Section 3 became part of what you call, following Professor Levinson and heuristics, the constitutional of memory. Part of a constitution, that part of the constitution made of potentially important provisions, but with no practical vital role in current constitutional politics. Now, because of your great work, because of the liberal trends going on, because of the Trump disqualification litigation, many remembered the existence of Section 3 of the 14th Amendment. It is no more forgotten. So my question is, after Trump v. Anderson, is there any further possibility for Section 3 to pass from that part of the Constitution of memory, to become part of a constitution of conversation, as Professor Levinson put it? So to play a vital role, a practical role. So in particular, is it possible for the Congress to play in the future the role that Trump v. Anderson suggests, and in a certain sense give teeth to Section 3? or in case it's possible for the states to use disqualifications under Section 3 to disqualify a person from holding state office, although not federal office, as the Supreme Court put it, and in politically concrete and meaningful ways, and in doing so to have an influence, concrete influence against current illiberal trends. My question is about the future perspective of this debate. I'm particularly interested in this because of the general contour of the book and, of course, the last judgment of the Supreme Court. Thank you for the attention.
Thank you very much, Leonardo. So I think that now we can have Mark reply to the comments, and then we can open the floor for debate. So Mark, do you want to reply to the discussions?
I'll just make one brief thing. I think I'll save all replies to the end because I've already heard what I have to say, and frankly, it's a little tiring after a while to listen to oneself, but I'd rather hear new voices. So 2 comments. One, probably the most important thing I say, I find I have incredible energy when I'm standing up and talking. I've sort of worked out how to do it sitting down. I apologize. It's even harder when you're half lying down. If you saw me, I'm trying to adjust things, so I'm actually sitting up. But this is the most important thing I can teach all of you. If you have the opportunity to stand and do one of these things, stand. The other thing I'll say, because I think it ties 2 things together, and I will say more at the end, and that is originalism and militant democracy. And it goes like this. A few years ago, we had an understanding of militant democracy that was rooted particularly in a number of what European countries were doing and some other constitutional democracies around the world. And then this year we asked a question. Is Section 3 militant democracy US style? And what I want to suggest actually is we probably can't answer that if we ask, what was the original understanding of militant democracy? Because it hadn't really considered the American version. You can make a case. It's a cousin, but not militant democracy. And if you do that, you will be changing somewhat the understanding of militant democracy. You can make a case it is a form of militant democracy. That will also change the understanding of militant democracy. The broader point here with respect to originalism is my suggestion that originalism really is very thick. You cannot understand what slavery, non-discrimination meant to the framers of the 14th Amendment unless you understand their entire worldview, which consisted of not simply, law, but general principles. Tim Sellers will be very good to remind us of the general principles, and empirical facts about the world. And inevitably, the problems we ask of originalism occur because something about our fundamental principles, something about our knowledge of the world has changed. So Sandy Levinson is exactly right. We don't ask questions about certain provisions of the Constitution, some of which the meaning seems to be clear. Others we can come up with hypothetical exceptions, but nothing in our world has changed. We take for granted their solution. But the idea is, as I hope the example of what is militant democracy, is originalism serves us the least when we need it the most. So I'd rather have questions, and then as I've got more things to say, about American style militant democracy and originalism. And as an academic, and as all of you know, all of us will always have more things to say. But probably important other people get their say in.
So thank you, Mark. And so I would open the floor for a Q&A session. Is there anyone who wants to step in? Tim Seller, great, please.
This is going to be more by way of provocative comment than actual question, but first of all, like Professor Levinson, I agree with Professor Graeber's thesis, and I also agree on the excellence of his book. So it truly is a good book. And with respect to originalism, you know, if you want to be originalist, you have to read this book. The trouble with originalism is the history is terrible and they're always wrong. And so actually they could learn something if they actually read the book. I like the emphasis on structure and the structural aspects of constitutional design, which was, after all, the central concern of the framers of the actual first United States Constitution of 1787. So both in 1787 and in 1868, these structural ideas were right at the forefront. It was the main thing they were thinking of. And indeed, I think it's still at the heart of the Constitution that we actually have today. So as I teach constitutional law, and as I was taught it, and as I think most people teach it, the first half of the course is purely structural. And in my university, that's 4 credits. And then the rights only follow afterwards, and that's 2 credits. So I think the structure is very important, and I think we're still aware of that. If I disagree with Mark at all, I think it would be in his, and I think this was mainly rhetorical, but his dismissal of Article 1 of the 14th Amendment. So I think Article 1 is extremely important because it sets out the principles and the values that we are trying to achieve by having the 2nd, 3rd, and 4th sections of the amendment. So Article 1 is a declaration of principles that we're implementing. And what we're doing with the 14th Amendment, I think, is very similar to what the framers of the original Constitution did in 1787, which was to rule out a whole set of points of view that just simply were going to have to be outside the debate. They all agreed on certain points, and then if we're going to divide into parties, you have to be within these parameters. So for them, no monarchy, no oligarchy, and also, by the way, no democracy. So I think we're making a mistake when we talk too much about democracy in connection with the United States Constitution, which has never been a particularly democratic constitution. But the idea is that new parties would have to share these commitments. So with the 14th Amendment, we had learned a lesson from the violence of the slave power, and therefore we properly ruled out certain political positions and certain political actors. And we did this, I think, very properly. But I don't think there's much value in calling this democracy or militant democracy. I would call it either republicanism or constitutionalism or something like that, because these constraints are completely useful and reasonable constraints on democracy. They're ruling out what would be the illegitimate exercise of public power. So if you implement democratic power to achieve more slavery or to advance a rebellion, those are things that we very properly rule out and forbid, even if populist democracy would make it so. So I don't think the United States really needs to talk in terms of militant democracy, because actually we have built into our system already and into our tradition a resistance against kind of corruption that you see, or with certain types of democracy. And we've given the example of our own recent bad experience. So those are my observations, which are entirely positive, but I tried to say 1 or 2 things that would provoke a reaction.
So thank you very much, Tim, very provocative question, also for Europeans, for the European perspective. So I will collect another question, but before this, I would like to thank Professor Levinson, because I know he has to leave for teaching class. And so thank you very, very much, Sandy Levinson, for your really, really precious comments and insights on the book, and more in general on the US constitutional history. So I have seen another question, probably by Nixon Mayekaira.
Yes.
Before, okay, please.
Yes. So first of all, thank you so much for the presentation. I just have two questions. One is that I think when Professor Mark Graber speaks about, emphasis on the structure, my thinking is that is more of context, because I think looking at the American Constitution and the challenge they've had in terms of what you call amendment, the difficulties they've had in terms of amendment, I think now the move has been to what you call to the structure. And I think there's also been a lot of emphasis on what you call the Supreme Court and the way it rules and interprets what you call constitutional issues. So I think when you try to extrapolate that to other regions, I think the dynamics will be very different. So I don't know what Professor thinks about that. That is one. Secondly, and sorry, now I think Professor Levinson has left, but my question was to him. He mentioned that one of the things that will be useful will be the idea of militant democracy. And I'm just wondering, at the point we are thinking of designing or coming up with constitutional designs that looks at how to tame or control populism, are we missing the picture? Because these populists kind of have a constituency whom they appeal to. This constituency will always be there. So is there something we are missing in terms of really addressing the constituency and the need? My thinking is that I think it could be maybe we are putting the cart before the horse. Thank you so much. My comments.
Thank you very much. Maybe Sandy, if you have time, do you want to reply quickly?
Yep. Gladly. 2 points. One, perhaps channeling my inner Mark Teschnit, I would caution against identifying anti-democratic forces with populism. That there are certainly populist movements that could be described as anti-democratic or anti-republican, but I think that there are populist movements that aren't, and that at least some of the current political dialogue in its anti-populism tends, in fact, to turn into a defense of what used to be called elite democracy or elite republicanism, which I think is subject to genuine debate. The other point I want to make before I do have to slip out, Tim is certainly right that a lot of constitutional law courses talk about structures, but I would want to say, and here I'm again reflecting my knowledge as an American academic, structural analysis for almost all American law professors is what the Supreme Court defines as structures. That's federalism and things like presidential power, power of the executive is against power of Congress. These are interesting and important, same way that, First Amendment is interesting and important. But the structures I'm most interested in are the ones that law professors law professors in the United States almost literally never teach, because there's nothing to litigate. I am well known for my militant opposition to the US Senate as illegitimate because of its malapportionment. With Wyoming, with 550,000 people, has the same number of senators as California with 40 million people. This is really not subject to litigation because all you have to do is read the Constitution and know what the number 2 means in order to know that there's nothing unconstitutional about this feature of the US Constitution. It's simply dreadful and indefensible in terms of normative political theory, but lawyers will never litigate it, and thus American law professors never teach it because we define the subject matter by what is litigated. So I might be importing too much of how Americans view American constitutionalism. I would be truly interested, and I have about 8 minutes more before I slip out, in what European law professors teach their students about what I call the hardwired structures that aren't subject to litigation. There aren't going to be cases in the Constitutional Court because they are just the basics of the constitutional order that don't raise any interpretive questions. I learned yesterday in my comparative course that the king of Norway must be a Lutheran. We undoubtedly could debate that for a long time about the wisdom, the legitimacy, this, that, or the other. But I assume that one would never litigate in a Norwegian court or take to Strasbourg the fact that this is discriminatory or whatever. It's just the way that Norwegian politics are organized. And it's those structural aspects that I think are ignored in American law schools. So the fact that we might teach Supreme Court cases on federalism doesn't really assuage my own problems.
Thank you so much. I don't know if there are other questions or comments or reaction. Giuseppe, please.
Thanks indeed, Antonia. I mean, just to say thanks to all the speakers, and I would like to build upon what the Professor Levinson and Leonardo were saying in their comments. Indeed, the Professor Levinson, we have in Europe these huge debates about the duty of the European Union to preserve the national identity, understood also as constitutional identity of the member states. So in this sense, the Court of Justice has to find that a very problematic balancing between this duty to preserve pluralism inherent in the fundamental choices, enshrined in the constitutions of the member states. At the same time, it has to preserve the homogeneity clause, let's say, enshrined in Article 2 of the Treaty of the European Union, so the fundamental values. And in this sense, the works by Antonia Baraggia are, of course, very important. So, but I would like to say something also on the concept of militant democracy as a general category that can be applied to the American context. Let's say that the concept of militant democracy is something that, as Leonardo said, is in a way inherent to what we call in Europe the memory of horror. So the idea of a certain type of post-totalitarian constitutionalism which was shaped by the memory of evil. But the fact that there were some political choices that were seen as of course, terrible, and post-totalitarian the constitutionalism has tried to let's say, use the constitutional design to in a way, I mean, prevent the political actors from again, I mean, making this mistake. So in this sense, the 14th Amendment can be seen as another product of the memory of horror. It is the outcome, of course, of the Civil War. But I think that analogies, I mean, stop here in the sense that at least in Europe, the idea of militant democracy is very much, I mean, related to the existence of a sort of untouchable core, which is preserved by the existence of an eternity clause. Right, so the idea that there is an area which cannot be reshaped by the political power. So in this sense, that the constitutionalism is, in a way, enriches, is counter the majoritarian flavor. And this also explains why in Germany, the defender of the essential core of German constitutional law is the German is the federal constitutional court, of course. So it is a concept which is selective in the sense that it implies the existence of some values that are seen as in a way supreme. It is also hierarchical. And militant democracy is also a concept which, in theory, at least can be used to exclude the application of the balancing test. While in the United States of America, this is at least I mean the main impression I have. I think that the importance of political and popular constitutionalism inevitably makes the application of this concept much more difficult in the sense, and perhaps, I mean, Trump versus Anderson confirms that when I see a lot of political deference also used by the Supreme Court in this case, then I don't know if this can be explained in the light of the particular composition of the court currently in a way. So if that was a political strategy adopted by a very politicized the main court currently, or if they conceive this section of the 14th Amendment as a clause which should be interpreted by the political actors mainly. So these were some comments about the analogy proposed by Leonardo. I'm curious to listen to Professor Graeber, of course, and let me say once again, thanks indeed for this beautiful gift. Thank you very much.
Thank you, Giuseppe. Is there anyone else who wants to step in? If not, I would give the floor to Professor Tim Seller again, because he has a follow-up maybe, and then I will give the floor to Mark for.
Yeah, so I'm only speaking because others are not, but I really like the reference to Article 2 of the Treaty of the European Union. I think this was a really important observation because I think this is the heart of the matter. And I think Article 1 of the 14th Amendment serves a very highly analogous purpose to Article 2 of the Treaty of the European Union. And I think for European Union lawyers, I mean, that's what I would be writing about, is what I would be thinking about, because it really is, you know, and we annihilated our Republican form of government clause. But, you know, Article 2 can serve that same purpose. So I was really pleased to hear it referred to, and I think it's highly closely related to what Professor Graeber has told us.
Thanks.
So, thank you so much also for this suggestion for European scholars. And so now I give the floor to our special guest. So Professor Graeber, the floor is all yours.
Try and sit up and at least get some degree of energy from sitting. let's start where we ended with Section 1 of the 14th Amendment, Article 2 of the treaty. And it's interesting in this respect that I've won one battle. When I present this, and I've now been presenting something like this for a number of years, I get substantial concession, from example, Professor Sellers in the United States, that they have underestimated the importance of sections 2, 3, and 4. So in some sense, I could say, if I had simply said, I've discovered a new Picasso painting, and guess what? It's as good as the old Picasso paintings. I think if that would have been the main thesis, I think it would be fairly uncontroversial. I'm actually saying I've discovered a new Picasso painting, and it changes everything you think about the old Picasso painting. So what are my reasons for not simply celebrating 2, 3, and 4, but downplaying 1? The first reason is simply historical, because outside of Representative John Bingham of Ohio and one speech by Jacob Howard, which he never repeated, that's what they did. So it may be that Section 1 is really important, but they didn't think so. It is rather remarkable. I'm now going through African American newspapers at the time. They're talking sections 2 and 3. Well, why did they think Section 1 unimportant? The first reason why is they thought the 13th Amendment said it all, that what they understood slavery to mean, particularly by the time they were debating the 14th Amendment, was slavery wasn't simply one person owned the labor of another. The opposite of a slave was not a free person. The opposite of a slave was a citizen. And citizenship came with a whole robust set of rights. So it is rather remarkable. You see in the book I talk about Republicans actually propose about 50 versions of the 14th Amendment. And some of them have Section 1s and some of them don't. But after Republicans passed the Civil Rights Act of 1866, which guarantees lots of rights, they stopped talking about the need for rights of this sort, to the point where one of the more radical Republicans, a senator named Henry Wilson, is talking about the 14th Amendment and the need for the 14th Amendment, and he doesn't even acknowledge the existence of Section 1. A second reason why Section 1 is important is read Section 1 and ask yourself, just on the basis of the text, what is ruled out? And one of the things I'm actually going to be talking about over the weekend, Professor Levinson says it comes to see me over the weekend, is it actually turns out that all of these phrases occurred before the Civil War. Those phrases were in state constitutions, and they were interpreted as allowing massive discriminations against African American and massive discriminations about what we would call fundamental rights. In other words, both Democrats and Republicans knew well that what really was going to matter with respect to the 13th Amendment in Section 1 was who was doing the interpreting. And what they say is, if you get the interpreters right, won't matter what you say about the rights. They'll get it right. You have to say something, but it doesn't matter the details. If you get the interpreters wrong, won't matter how good you are with the right. So I always want to say, I emphasize that I suspect Professor Sellers and I have very little disagreement about the values Republicans want to pursue, that of a free labor, racial egalitarian democratic republic, we might call it. We simply dispute how important most of them thought Section 1 was to the pursuit. And the evidence of that, I want to suggest, is that they all thought the pursuit would be facilitated much more by Sections 2 and 3. Now, it's important with the conversation on populism is the Republican Party was probably the populist movement of its time. It was not particularly an elite-driven party. It wasn't really an anti-elite party. But what Republicans said was, vote for us. That's how we're going to stop the spread of slavery. We're not going to go to court. We're going to use courts to publicize our cause. But basically, as William Seward said, we are going to organize and we are going to outvote you. And once we become the majority, we will, in fact, instantiate our constitutional vision. So notice an interesting feature about Republican entrenchment. Normally, when we think of entrenchment, we have things that are anti-democratic, that people make the Constitution a little less democratic. You can't vote on this. We're going to entrench the principle of private property. You can't vote to take it without compensation. Or we get to be in power longer, or we empower our supporters in the judiciary. Democrats also sought to entrench their power. But notice what they did. They entrenched by making the Constitution more democratic. Now, they didn't make it as democratic as Professor Levinson would want, but what they said, here is a provision in the Constitution that you get to have representatives for people who do not vote. The result being, say, a voter in one state has twice the power of a voter in another state. No, we're not going to do that. They, in fact, announced, at least for the House of Representatives, it's going to be one person, one vote. It's the population of your state, but if you take the ballot away from people, we take representatives away from you so that every person cast a ballot of the same weight. So the entrenchment is somewhat different, and it's important to know it's a populist party seeking to make the regime more democratic. And one of the things they do is they don't go back. So one of the features of a certain contemporary populist party, and Yaniv Rosnag gave a great paper on this that Antonia Baraggia and I listened to this morning, is that the populist party makes a rule at day one, which serves them at day one. At day 3, they make a new rule, which serves them at day 3. Republicans don't do that. No, they say, here are the rules. It's a more majoritarian rule. So now to the question of militant democracy. And American militant democracy is different in a number of ways, some of which we've discussed, some of which we haven't. So Holmes says that if the population wants the dictatorship of the proletariat, I'm not going to stand in their way. And that's actually true. Because if you look at Section 3, if I were to advocate the dictatorship of the proletariat, if I were to advocate hatred against minority groups, if I were to advocate any substantive policy, including people I like, or there ought to be a law that permits you to legally assassinate people I like. Nothing in Section 3 bars me from office. Section 3, unlike a great many European provisions, is an action provision, not an advocacy provision. Section 3 says if you've performed a certain action in the past, engaged in insurrection, you're barred. And one of the things I always used to tell people is it doesn't bar any policy. So imagine we had disqualified Donald Trump. Someone else would have run for office and said, here's what I'm going to do. Every morning, I'm going to call up Donald Trump and say, here are the decisions I have to make today. What should I do? By the way, Donald Trump will have my cell phone number. I will carry it on me at all times. At any point, Donald Trump can call me and say, you need to do this, and I will do this. That person is eligible for the presidency because they have not performed the forbidden actions. What American style militant democracy says is we're not going to limit the policies people may democratically vote on, but we're going to try to make sure that the policies reflect the vote. So Lincoln had a quote that I love and I use over and over again, and that is, when ballots have been counted, there is no recourse to bullets. When the people have voted and one party has won by the rules, there are two things the other party can do. First, the other party can do their best playing by the rules to obstruct the other party. The other party has no constitutional obligation, no legal constitutional obligation to help the party in power. If there are 2/3 requirements, the other party can say, no, we're not giving you the votes. Second thing the other party can do is they can organize for the next election and do better. What the other party cannot do is attempt to obstruct what the winning party has done by force, violence, or intimidation. That what is ruled out in American-style militant democracy is, in fact, political figures who attempt to influence policy, not simply by gaining votes and persuading people, but by using force to interfere with policies they don't like. So it's an interesting difference in the question of, do you call it militant democracy or not? And here, as I emphasize, again, in some ways, whatever choice you make changes the understanding of militant democracy. Now, there's a second feature of it, which reflects the Republicans' notion that their strength was in Congress. Republicans expected Congress to carry out the 14th Amendment, not the courts. This is not to say they didn't think courts would have a role. What it is to say, and it's hard to explain to people, they didn't think of courts very much. Courts had been pro-slavery. They simply could not imagine courts that would lead a crusade for racial equality. What would they have thought of courts that were leading a crusade for racial equality? What would they have thought of the internet? What would they have thought of having meetings by Zoom? The answer is, who knows? We can make educated guesses, but we should acknowledge again, with the case of originalism, we are making guesses. There is nothing in what they said that gives a firm answer. So the question is, could Congress police the electoral process? Could the states police the electoral process? They simply didn't trust courts. And this goes into simply the last thing I want to say about originalism. There are a number of different kinds of objections to originalism. The first is, we don't like what they did back then. We shouldn't do it. A second is, regardless, we should not allow ourselves to be ruled by the dead hand of the past. So it's important to say, people who say things like that, we all agree, we can learn from history, but there's a difference between learning from history and being compelled by history. So one example I can give of this is, I'm a somewhat serious chess player, and as a kid I was very serious. And I studied the past games of great masters. And I would get myself in a position. I said, this position looks like a position one of the great masters was in. And the great master played this move. But of course, my position was somewhat different. And so I couldn't simply just play the move the great master played. I had to think for myself, well, here are the similarities, here are the differences. Given the similarities and differences, do I play the move the great master played or not? So what I've been trying to argue, and part of what this book project will argue, is it's a mistake to think the framers of the 14th Amendment had simple ideas that we can translate easier to our time. They had ideas of paradigm cases. The black codes were wrong. They had beliefs about general principles. A free labor system was a really good idea. They had beliefs about institutions. Congress is the place best enabled to deal with threats to racial equality. They had beliefs about the way the world worked. Men and women were different. To understand their 14th Amendment, to do originalist history, is not to isolate one of them, but in fact to come up with a very thick web of beliefs. What we then discover is we can't even recover that thick web of beliefs. So one last example I like to use. In Salem, they believed in witches, Salem, Massachusetts. Maybe in your culture they did as well in the 17th century. How do you know what a witch? Well, you know a witch when you looked at a woman, you got a certain feeling in your stomach. We can't duplicate that feeling because they thought it was a witch. We now think it's heartburn. We cannot duplicate that sensation. We can play a game with the class, identify the witch. But we cannot have the experience people of Salem had when they thought witches. All we can do is say, here's what they thought. Can we, given the foundations of what they thought have eroded, what do we now think? And the answer is, if you cry witch, no, take an antacid, it'll go away. So this is what I want to do in some way, is to create a thick description that suggests Americans, 19th century, had some ideas that aren't simply American. It's not simply American exceptionalism. They were experimenting with things that look like they may not be. Militant democracy. They understood the value of structure, and there are a great many things we can learn from them, the most important of which may be that we're not compelled to follow them. I thought that was my brave, bold ending line.
Yes, so thank you very much, Mark, for the book above all, and for this lovely discussion that personally raises several issues from the European perspective that needs to be so studied and reflected upon. So thank you very much to our guest, to our discussant, to the audience, and to our host, so Giuseppe, Martinico, Giacomo, and all the Sant'Anna team, which is very, very big. And so thank you all.
Thank you again. It's really, as I think we all know, just we live for audiences that take our ideas seriously. Thank you.